It is now.
Great, thank you. So I just want to say thanks, and as you can see, we're learning all about this as we go along. So work with all of the technology and make sure that it works to the best of our abilities. We'll use the chat room, and so if you have questions or conversations that you want to have in the chat room, great. If you have specific questions for the panelists, use the Q&A tab, and we'll make sure that we monitor that as well. I want to just do a quick announcement. We are going to do another webinar in the next week or so, probably on the 27th of May, around risk assessment, risk management, and a return of sailing operations. And so that'll be a really good one. We'll have another panel of experts to be able to talk about that. And so we will invite you to participate in that. We'll get the link up on the website as soon as we can, and then get it distributed out on social media. Tall Ships America, as you know, is also hosting some meetings, and would like to invite you to our website to check those out. We've got regional meetings, meetings for captains, and meeting for our rising professional mariners. And we want topics from you all to know what it is that we should be covering. But please contact me directly, Chris at tallshipsamerica.org, and let me know what kind of conversations that you want to have as part of our meetings. So with that, I am going to sign off and enjoy the webinar, and I'm going to turn it over to Jen Haddock from SEA so she can get this thing started. Thanks, everyone.
Thanks, Chris. First of all, my name's Jen Haddock. I'm the port captain at Sea Education Association. I'm very excited to introduce Juliet, who I've known for quite a while. She started sailing at SEA as mate and also spent some time on sound water, so she has a solid background with our industry. And then went on to graduate from Wellesley College, and then on to University of California's Hastings College of Law, and has a maritime law degree focusing on Jones Act issues and litigation. So she's a great asset to have on board here. And she's also currently the board member at Call of the Sea. So please welcome Juliet. Thank you, Juliet.
Welcome. Thanks, Jen. So do you want me to jump in? Jonathan, did you have anything to say? You're on mute.
There we go. Just wanted to reiterate how delighted we are. This is one of the many activities historically that the Ship Operations and Safety Committee has undertaken to provide guidance, content, best practice to member vessels, operators, and the members themselves. The impetus for this session was several points being raised in the both executive directors, Zooms that we've been having weekly, the captain Zooms, and some of the Rising Professional Mariner Zooms. And it seemed that it was prudent to sort of reintroduce some of the basics covering particular aspects of the Jones Act, particularly to maintenance and cure, not only in regard to COVID-19, but more generally in terms of what the obligations are, etc. So we are delighted to have Juliet McCullough with us today, who comes to this not only as a maritime lawyer, but as a former ship crew member and officer within our fleet. So just a couple ground rules. We encourage lots of question asking. There weren't any questions sent in advance. If you do have a question, please enter it in the Q&A, which you should find on the lower right-hand section of your tab bar under the speaker. And if it seems like we're at a good point to answer it in the course of the presentation, we'll go right ahead and do that, and I'll interject and ask the, sort of prompt the question. Otherwise, we'll circle back to it once the formal presentation is finished. And with that, I'll turn it over to you.
Thanks, Jonathan. Thank you, Jen, for the very nice introduction. I'll share my screen here so you can all have something to look at other than me. So good morning to everyone. Thank you for joining in this webinar. I appreciate your interest in this topic. It is what I spend my days dealing with now on a very different side from when I would hear these phrases such as Jones Act and maintenance and cure and unseaworthiness when I used to work on tall ships. So what I'd like to do with this presentation is just give you a brief overview and take about half an hour to discuss the major concepts. I know that even amongst maritime attorneys, some of these concepts are tricky. They're they're more nuanced than they may seem. So I'll try to give you the really, really broad view so that everyone has a fundamental understanding, and then spend the rest of the time during this webinar answering questions, which I hope you'll all feel comfortable asking me. The title of this presentation is Seafarer Protections, and the reason I called it Seafarer Protections instead of the Jones Act or Maintenance and Cure is that there are 3 specific protections for seafarers that are not available to any other employees under American law. So there are 3 distinct ones. I will go through them all and hopefully try to give you a background so that you can all talk knowledgeably with your fellow crew members and understand a little more both what as an injured seafarer one might be entitled to, and from a management perspective, what the potential obligations are, because it's fundamentally different from the workers' compensation scheme that shore-based workers are protected by, and even the federal workers' compensation scheme for longshore and harbor workers. So with that, I will jump in. So just a little introduction on maritime law. Maritime law actually dates back hundreds and hundreds of years. Originally, maritime laws were intended to protect those who went to sea, because those who went to sea for a long time, unlike all of you fine folks, were considered to be uneducated, unintelligent. Courts often referred to them as friendless, and therefore in need of court's special protections in the same way that children would be in need of court special protections. That's not necessarily the case. Certainly in the tall ship industry, most people are fairly educated and have plenty of friends, but the protections that apply to all mariners under United States law apply to both merchant mariners, so those who are working as oilers or as ordinary seamen on a Crowley vessel or a Matson vessel, as well as those who are working on tall ships, whether it's a sailing school vessel or a tea vessel. Mariners' rights are all the same. And it's important to realize that the purpose behind these laws is really to protect those who are in this industry as a means to make a living, who don't have a ton of other options. And so they're very, very protective laws, and we'll jump into each of them. There are 2 sources of law, and this is just a tiny background on the way our legal system works in the United States. There's statutory law, which is law that's created by a statute that's been passed by Congress, and then there is common law, and common law is law that the courts have created. So the laws of negligence, for example, are common law claims, and the common law, which means that the federal courts in the United States, all the way up to the Supreme Court, have defined 2 protections for seamen. And when I say seamen, I should say seafarers. That should be a gender neutral term. One of those rights that comes under the maritime law is the right to maintenance and cure. One of them is the right to a seaworthy vessel. And then on a statutory law perspective, the Jones Act was passed in 1920, and it gave mariners the right to actually sue their employer for negligence, which causes a personal injury or death. And the reason this is a big deal, and before I went to law school, I wouldn't have understood this, but shore-based workers cannot sue their employer for negligence if they are injured on the job. They're entitled to the workers' compensation scheme set forth by their state. And that has a schedule as to what benefits might be available to the injured worker. When you sue your employer, you are claiming entitlement to pain and suffering damages, to lost earnings damages. So the damages are very different and much broader. Hopefully those of us in the tall ship industry are here because we love it and generally not super litigious towards their employers, because most people enjoy the mission of what they're doing and are not looking for an easy buck. If they were looking for an easy buck, they probably wouldn't be tall ship sailors. But the right to maintenance and cure does not require a lawsuit. So that's the first thing that we'll dive into after we establish what is a seaman. So again, apologies for the term seaman, using seafarer instead. The United States Supreme Court has actually established a test for determining who is a seafarer and therefore would be entitled to these 3 benefits that were on the past slide. One of the prongs in establishing that someone is a seaman or a seafarer is that they spend 30% of their work time on a vessel or a fleet of vessels in navigation. So, for example, some employees work in the office part of the time and work at sea part of the time. Someone, to use some industry examples, if you think about a head educator for a passenger vessel that takes students out, that head educator might come in and spend a day in an office and then 4 days or 5 days out on the water with students. So that's more than 30% of their work time they're out on a vessel. Occasionally there are employees, generally not as much in the tall ship industry, but who spend only about 10 or 20% out on the water. They would not qualify as seafarers because the essence of their employment relationship is not as a mariner. The vessels must be in navigation. Now, this is also an issue that has been evaluated and opined upon by the Supreme Court in many different instances. A vessel doesn't have to actually be underway to be in navigation. What it means to be a vessel in navigation is that the vessel is in navigable waters, which means waters that you could actually make way through, and that it could leave the dock, not that it actually is leaving the dock. So if a vessel is tied up because there simply are no passengers who want to go out, or there is maintenance happening, say you have a yard period where the vessel's in the water, it's not hauled out, that vessel is still in navigation. And then the final element of the seaman or seafarer status test is that the person's employment must aid in the mission of the vessel. This is often an element that some people get hung up on. In order to aid in the mission of the vessel, you don't have to be in the deck department or in the engineering department. If you have a tall ship sailing out in San Francisco Bay, which is where I am, and for the most part, that tall ship takes out sunset sails and other public sails, and there is a bartender who is working on that vessel. That bartender is a mariner or a seaman entitled to these benefits. There are some special exclusions for sailing school vessels, and I will get into those, but there's ample case law that says, for example, a card dealer on a casino vessel is a mariner. A wait staff on a dinner cruiser is a mariner. So if the vessel's mission is taking passengers out and serving them dinner, then anyone who aids in that mission is in fact a mariner. And there's a phrase that gets thrown about very frequently, and that is that an employee cannot walk in and out of seaman status. So if you are a seafarer, if the nature of your employment relationship is as a mariner, it doesn't matter where you are at the time you are injured. I handled a case out in Hawaii about a year ago where the injured employee was injured in a storage facility that was inland. And it did not matter that the storage facility was inland and that he was injured when something fell on his shoulder there. He was still a seaman because he spent more than 30% of his time on vessels, and it didn't matter where the injury had actually occurred. Not seamen or not seafarers, passengers, so anyone who's paying to be on board the vessel, students, and that's, I'll get into the special rules for sailing school vessels, but those students are not seamen. Longshore workers and harbor workers, so those who come aboard to assist with maintenance or who work on the waterfront but don't actually go to sea and aren't exposed to the perils of the sea. Independent contractors and supernumeraries. And supernumeraries is a fancy word for saying someone who's on board who hasn't paid to be on board but is also not being paid. So for example, back in olden times when masters were only ever men, which they certainly are not now, the wife of the captain or the children of the captain would be supernumeraries. They weren't paying to be there, they weren't a member of the crew, but they were on board and therefore increased the count of souls on board for a deck log. So special rules for sailing school vessels. In 1982, there was legislation passed that said that the students and instructors on sailing school vessels are not seamen. They're not entitled, therefore, to maintenance and cure. They're not owed the warranty of seaworthiness, and they're not entitled to other benefits and protections that seafarers and mariners would get. So if you think about a sailing school vessel, you might know about those of you who are familiar with them. The members of the crew, so deck department, engineering department, scientists possibly, they're all, and stewards, they're all seafarers, they're seamen, they're entitled to all these benefits. But if a maritime studies professor who isn't normally out on the water and maybe comes out one trip a year, is on board, they would be considered an instructor. So as you can see on a sailing school vessel, there are actually some people who are paid by the vessel owner or operator and who are out on the vessel who would not receive these protections. And the same goes for the students who, on a sailing school vessel, of course, there are no passengers. The students are expected to stand watch and to be active members of the crew who would respond in emergencies, have a position on a station bill. But because they are in fact paying to be there, they're not members of the crew and they're not entitled to these protections because they're not there in order to try to make a living to feed their family. At least that was the thought process behind these exclusions. And I'll note that as of the last publication by the National Vessel Documentation Center, there were 62 US flagship sailing school vessels. So some of you have probably heard of or been involved with at least one of those. So the first thing I'll talk about, which I think is most relevant to tall ship sailors, is the no-fault remedies. So this means that these are things that are entitled to an injured seafarer, regardless of whether or not that seafarer files a lawsuit, which is better, I would say. As a litigator, litigation is not fun. No one benefits from litigation. So if a seafarer, as we've just established the definition, is injured or an illness manifests while that seafarer is subject to the call of the vessel, that seafarer is entitled to maintenance and cure. They don't have to prove that anyone did anything wrong. They don't have to hire a lawyer. They don't have to do anything. And as a just matter of course, the operator and owner is obligated to produce maintenance and cure. So what does that mean? Maintenance is a nominal living stipend. It is intended to provide for a seafarer who no longer gets to sleep aboard the vessel because he or she is injured. It's not a large sum of money. It's not intended to make life cushy. But if you go back in time 100, 200 years ago, if an American seafarer was injured, broke his arm while the vessel was in Shanghai, and the captain said, well, you can't come out, you have a broken arm, you're of no use to me. And that mariner had to stay in Shanghai with no way to live there. The vessel owner and operator was obligated to provide a living stipend that would provide for very basic living accommodations for the seafarer who's just lost the roof over his head. These days, seamen who are subject to collective bargaining agreements generally have in their collective bargaining agreement a pre-agreed amount of maintenance. Generally, these amounts range between $20 and $40 a day. So it's not a ton of money, but that is what maintenance is. You do it the second you become injured and sign off the vessel is not fit for duty. So what about cure? Cure is medical expenses until a seafarer reaches maximum cure. It's also reimbursement for travel to those medical appointments and supplies and durable medical equipment. So if you need crutches or whatever the case may be, those all fall under the definition of cure. So these are two things that an injured seafarer is entitled to just by the fact that they become injured while subject to the call of the vessel. They don't have to have been actually performing a task for the vessel at the time. They don't have to have actually even been on board the vessel at the time, but it's considered implicit in the employment relationship that if a seafarer becomes injured and not fit for duty, that the employer will basically take care of the seafarer until they reach maximum cure. The reason the topic of maintenance and cure is such a big deal is that the obligation to provide it arises automatically. And if an employer is found in court, so if ultimately an injured seaman decides to pursue litigation and the parties find themselves before a judge and jury, if the employer is found to have willfully and wantonly failed to provide maintenance and cure that were due, then the seafarer can be entitled to punitive damages. Punitive damages are a fancy way for saying a huge pile of money that you otherwise wouldn't be entitled to. So they're not based on your actual damages. They're not based on the harm you're suffering or economic loss. They are intended to punish the party that has done the thing that the courts have decided is wrong. So if, for example, an operator knew that someone was injured while subject to the call of vessel, that person said, hey, I was injured, I need help with my medical bills, and the employer refused to provide that, that could be a basis for punitive damages, which of course cannot be insured. And our courts have held that because punitive damages are a punishment, insurance policies cannot cover them. So for a tall ship organization, which is generally operating on a pretty tight budget, this is a really significant deal. These are break the business kind of deals. So it's important to understand what these obligations are and to make sure that, that they're complied with. If an employee says, you know, I'm suffering from this strange symptom, my shoulder hurts, or I don't feel quite right, the employer has an obligation to investigate. It's not solely the employee's obligation to diagnose themselves. And these benefits, they continue until the seafarer reaches what's called maximum cure. And maximum cure is when reasonable medical procedures will no longer improve the seafarer's condition. So if you broke your arm and you were not fit for duty until your arm healed, as soon as your arm healed and your doctor said, you know what, you're clear to go, off you go, you can lift anything, you can push anything, you can pull anything, maximum cure has been reached. Sometimes with soft tissue injuries in particular, it takes a long time to get to maximum cure. However, one should always reach maximum cure because palliative care, which is just the treatment of symptoms to ease pain and make life more comfortable, is not considered cure. So once you get to the point, even if you're never ever declared fit for duty again, if you get to the point where reasonable medical procedures will no longer improve you, then you're at maximum cure and these benefits terminate. So then on fault-based damages, which means that your employer has done something wrong and that thing that was done wrong actually leads to your injury, or there's a causal connection between the thing that was done wrong and your injury. A seafarer can hire a lawyer, or if they want to represent themselves, and sue their employer for the negligence of either the ship owner, the captain, or fellow members of the crew. The standard of care in these claims is reasonable under the circumstances. That doesn't have to be the most safe practice ever, but it has to be something that others in the industry would consider to be reasonable under the circumstances. And notably, the seafarer, him or herself, can be found responsible for contributory negligence. So if maybe the employer didn't clean up a spill and that spill was slippery, but then maybe the seafarer turned on music and decided to dance in the slippery thing to make things a little more interesting because there wasn't much happening as the vessel was, you know, in the middle of the ocean, and then they fell and break their knee. Well, there's some contributory negligence there because a seafarer should not have thought, let me just dance around in this slip oil spill right now. So the obligation to act reasonably is both on the owner as well as the crew member. The unseaworthiness cause of action, which comes from the maritime law, so it's not from statute, it's just from courts of appeal and the Supreme Court holding over and over again that this is due to seafarers, says that a seaman or a seafarer is obligated or is entitled to a seaworthy vessel. A seaworthy vessel is one that is fit for its intended purpose. So that's a pretty loosey-goosey definition. And generally speaking, if someone is injured and they decide to litigate, they will claim both that their employer was negligent and that the thing that was involved in their injury was unseaworthy. So those two claims come hand in hand. In the unseaworthiness claim, there must be a causal connection. So you have to prove that the thing that wasn't fit for its intended purpose actually caused your injury. But the employer or operator does not need to know about that thing in order for it to be an unseaworthy condition. Notably, there's a significant case law that says that you don't have to have an injury-free ship. So just because someone is injured on board a vessel doesn't mean that the operator did anything wrong, that there was any negligence, or that there was any unseaworthiness, because it's not the employer's job to basically be the insurer of the safety of the mariner. So damages available to injured seamen, and this is important because tall ships generally don't have huge budgets, and so it's important to realize sort of what's at stake potentially, and hopefully all owners and operators have really good marine insurance that covers all but punitive damages here. The compensatory damages, which are the damages that are intended to compensate one for his or her particular losses, are medical expenses past and future, pain and suffering past and future, and lost earnings past and future. The punitive damages can be held to be capped to be 3 times what the combination of all those compensatory damages. The case of Exxon Valdez, the Supreme Court held that the punitive damages should be capped at 3 times that amount. So if you added up all the others multiplied by 3, that would be that uninsured amount, which is a real problem for the defendant. So as an operator or as an agent of the operator, if you're a master, it's really important after an injury or an illness is reported. And illness matters too. So if someone comes to you and says they have a fever and are feeling ill, that is treated the exact same way. And it need not be caused by anything done on the ship. If someone comes down with a dread disease while on board, they're going to be entitled to maintenance and cure until they reach maintenance and cure. So the operator should say, okay, first, do we have a seaman that we're talking about? If we're talking about a seafarer, we need to be really careful and make sure that we're really crossing all our T's and dotting all our I's, and that we provide all that that seafarer is entitled to. After we decide that we have a seafarer, we want to find out if he or she was injured while subject to the call of the vessel. So if you're talking about someone who's signing on for a particular contract of 3 months, during that 3-month period, they're more likely than not subject to the call of the vessel, even if they are on shore. If you have commuter seamen, which means seafarers that go home and live off the vessel and then come back every morning, then there's a little more wiggle room, and you're more likely to be able to find that they were injured not while subject to the call of the vessel if they were at home getting drunk and falling off of the balcony. But regardless of the answer to the first 2 questions, it's really important to document. So obtain statements from the injured seafarer as soon as possible. Take witness statements, even if the witness statement says, I didn't see anything. That will ultimately end up being important if you find yourself dealing with litigation. And the master of the vessel should prepare a report documenting everything that she or he found when talking to the other crew members, talking to the injured seafarer, and taking a look at the situation and circumstances where the injury occurred, if there was an injury instead of an illness that's reported. So that is about my time. I hope that there will be lots of questions. There's no question that is too specific. I'll try to answer them, and you guys have a good chunk of time to do that. And I'll stop sharing my slides, and then you can see a bigger picture of Jonathan.
Well, Juliet, first let me start by saying thank you very much. That was great. As we anticipated within this community, there are particular questions regarding the relationship between compensation and how that may or may not impact the definition of a seaman. So 2 questions, maybe you could tie them together. One is about volunteers and are they classified as crew? In particular, you said 30% of their time has to be in service to the navigation of the ship. 30% of what total amount of time? And then interns
Yeah,
who are not paid but are not paying, do they sort of fall into that same framework?
great. So two things. Yeah, the 30% is of employment hours. So if the employee works 40 hours a week, what is 30% of 40 hours a week? If they're on average spending more than that, then they would hit that element of the prong. In litigation, what we find is that, of course, the injured seafarer says, I spend 40% or 35%. They always, allege that it's something over the 30% element of their time at sea in order to gain those protections. Generally, there is some sort of log documenting how, in fact, the hours are spent. But yes, it's a function of out of your employment hours, because these rights all come out of the employment relationship. They're derivative of that relationship. And so that's what the 30% comes from. With regard to volunteers, there is Ninth Circuit case law. Ninth Circuit is the federal court of appeals that covers Washington, Oregon, California, Hawaii, that says that the element of monetary compensation is simply one thing that a court would look at in evaluating the totality of the circumstances as to whether or not this person constitutes a seafarer entitled to these protections. Case in particular that I can think of was where there was a Sea Scout vessel and a young man who was working on board who was injured, and he was not being paid. He was a volunteer, but he answered to the master. He wore the designated t-shirt. The master gave him performance reviews. So all these markers of an employment relationship were there, except for monetary compensation. And the court said, if you look like a duck, and you smell like a duck, and you walk like a duck, the fact that your feathers are a different color doesn't really matter. You're still an employee. So in all of these cases, it will be a totality of the circumstances evaluation by the court. And generally the tie goes to the seafarer, not to the employer, because courts generally look at this as though the seafarer is the underdog, and the tie should be split in his or her way.
So recognizing that every organization should seek guidance from their respective counsel, if a volunteer or intern is meeting obligations of a minimum manning document, the COI, probably likely that they would be considered a merchant seaman, correct?
Yeah, and so there are some things that can be done, certainly from a management perspective, in order to mitigate those risks. For example, if you have a true volunteer, and especially if it's a volunteer, some of the volunteers we see on tall ships are also donors, and they come out and they volunteer. It is good to let them volunteer, because then these people who have money to bestow upon the nonprofit organizations will do so. But they're not being come down upon by the master or the mate for, sloppy helmsmanship, or they're not being told, it is your turn to go clean the head, go clean the head. And so if they're being treated with kid gloves, and they're really, not being treated in the same way that an actual paid deckhand would be treated, then that will cut against them being considered a mariner entitled to these protections. Because these protections are supposed to come along with the bad, right? So the bad is that when you get yanked out of your bunk at 2 a.m. to go do, some line handling because there aren't enough people on deck, that's kind of a bummer. You wanted to be sleeping, it's 2 a.m. And if you have someone on board, I'm thinking in particular of like a development sale where you have people on board so they find their happy thoughts about the organization and then will dedicate money. They're probably not being roused at 2 a.m. and told they have to come, tend a sheet, because, we want them happy. So there's a whole host of things that one looks at. Of course, there's also the documentation possibility. So if you have people on board and you want to ensure that they understand they're not employees, they're not being evaluated as employees, they are purely volunteers, you get your lawyer to put together a contract that says that. It can be one page, and it's a waiver and assumption of risk. And it says, I understand I'm out here because I want to be out here. I'm out here because it's fun. I'm not being paid. I'm not an employee. And for me, this is a recreational pursuit that you are allowing me to do. So if you have something like that signed from a volunteer, then that's going to really cut against any claim that that person is a seafarer entitled to these protections.
Great. If you could just touch on the 30%, is that 30% of their time related to the organization, not 30% of time in a given week?
Yeah, so that's their work time for that employer. So for example, you and I both work for Soundwaters. If you think about Soundwaters, if you're the master or captain, schooner Soundwaters, there's probably some desk work you're supposed to do at the shore facility, which I can't remember the name of now, but you go to the shore facility, there's a computer there, there's work to be done there, but you also spend a whole bunch of time out driving the boat. And so you look at, okay, you as the master of the schooner Soundwaters maybe work 60 hours a week. Well, of those 60 hours, are you generally spending more than 30 of them actually on board the vessel as opposed to in the shore facility? So it's not all the hours that exist in the week or all the hours that the person's employed if the person works multiple jobs, but it's as a function of that relationship with that employer.
So if you volunteer, let's say 2 days a week, they're only taking those 2 days into consideration, that more than 30% of your time.
Yes.
What about, how does this pertain to foreign nationals aboard U.S. flag vessels? And likewise,
So
U.S. mariners aboard foreign flag vessels?
So foreign nationals generally don't work on U.S. flagship vessels. Part of the Jones Act, that legislation that came out in 1920, that gives a seafarer the right to sue his or her employer, also said that vessels that are performing coastwise trade, which means calling between two different vessels or between two different ports within the United States, and either transporting passengers or goods between two different U.S. ports without first exiting the domestic water, so going out into a foreign port, have to be U.S. built, U.S. flagged, and U.S. crewed. So you're less likely to find those who aren't U.S. citizens, but if you have a U.S. employer or U.S. owner, they are subject to jurisdiction in United States courts. And United States courts say that a vessel owner owes these duties and obligations to their crew. They don't say that they only owe them to their crew that are American, but in order for it to matter and have implications, you have to first have jurisdiction, personal jurisdiction over the owner in a U.S. court, because if you're not in a U.S. court, a foreign court in Germany or in China isn't going to enforce U.S. law. So you bring that employer into court here, which means that they're probably a U.S. employer, and then they're obligated to comply with U.S. law, whether or not their crew members are citizens, and they shouldn't be hiring for the deck department, at least non-citizens, because of the Jones Act, and that's a whole different situation for them to deal with. But it is not a defense in U.S. courts to say the person I harmed isn't an American, and therefore I should be free of liability.
And what about U.S. seafarers on foreign flag vessels?
So the challenge faced by U.S. seafarers on foreign flag vessels is that in order for them to enforce their rights, they would need to sue their employer in a U.S. court. And in order to sue their employer in a U.S. court, they need personal jurisdiction over that employer. Otherwise, the court says, we don't have any authority over this entity because it's not a U.S. entity. So it is possible that other countries have seafarer protections, and the crew member could seek benefits from whatever the judicial scheme is in the court that has jurisdiction over the entity. But it's going to be a challenge, especially if it's a small organization, to get the court to be able to help you, because basically the court has no ability to enforce a judgment against a non-U.S. entity.
What about someone that sort of transitions roles or wears multiple hats? So they work shoreside in whatever capacity they work, but they fill in for 2 weeks as the master of the vessel. If they're injured or hurt during those 2 weeks, are they a seafarer? Because your earlier slide said they can't walk in and out of the def.
Yeah, so it's true. They can't walk in and out, but and that is intended to mean like on a daily basis. They can't walk in and out of seaman status. but the nature of their relationship can change. So if you are working on shore as a professor and teaching students for 6 weeks, and then you take them out for 6 weeks and you are the master of the vessel, you are a seafarer there. And that would be basically a change in your status, which is not a function of where you physically are, but it's a function of the change in your job obligations. So if that makes sense, it's a kind of subtle distinction, but it's
we'll pick on my own organization because I'm sort of currently filling in as master. So if I'm sailing as master of the vessel, I'm a merchant mariner, despite the fact that I'm also the CEO of the organization.
correct.
Okay. But if, let's say, if you're, and from readings that I did on this previously, let's say the port captain, it is assumed that a port captain may spend a certain amount of time underway superintending the vessel at a given time, but that is different than that port captain signing on to the vessel as master or some other position for that fixed duration, in which case they once again become a merchant seaman.
Right, that's correct.
Great. You know, a hot topic for everybody here, we're all really wondering about this, is certainly COVID-19 and the relationship between commuter seafarers and an organization's responsibility if one of their crew members came down with it. You know, it's probably a little early in the process to have a lot of definitive guidance on that, but historically, has there been any situation where with commuter seafarers, it has been proven that they contracted the illness ashore, not in their seafaring capacity, and then alleviated an organization from maintenance and cure obligation? Or is it, does the location with which they sort of came in contact with the illness or developed the illness irrelevant in that case?
So there are a lot of elements to that question. If the crew member is signed on for 3 months, for example, and they go to shore to, you know, provision or pick up something from West Marine, and they contract it there, they're still going to be entitled to maintenance and cure, just as well as if someone had stepped on board the vessel and infected them on the quarter deck. When you're talking about commuter seamen, it becomes a lot trickier. Designating when an illness is contracted by someone who actually does walk away from the vessel and wash their hands in the vessel until they return, you know, 14 hours later. That would be harder to do. The thing to remember is that if an employer or operator does not provide maintenance and cure, and they are ultimately proved to have been due and that the seafarer was entitled to them, there's exposure to punitive damages, and that's a really big deal. And so I always tell my clients that if you're in doubt, you provide those benefits until you have really good evidence that you don't need to be in doubt and that this person got it from their girlfriend who they live with at home, and that is where the infection happened, and it didn't happen on the vessel. But until you have clear, as the operator, have clear and convincing evidence that it didn't manifest or the exposure wasn't while the seafarer was subject to the call of the vessel, the safest thing to do is always to provide those benefits. And they're not going to be that extensive. Cure is a pretty nominal amount per day, or maintenance is a pretty nominal amount per day. And the cure would be covering probably some number of medical appointments, and hopefully that there is some medical insurance that can help there. But it's very risky to not provide those benefits if there's any chance that the seafarer is entitled to them.
The questions are getting fired in here. Quick one, does the signing of articles have any relation to Jones Act seaman status?
So if someone is signing on articles, then they are almost assuredly a Jones Act seaman. And the signing of articles does have a number of implications. During the time that the person has signed on and is on articles, they're subject to the call of the vessel that entire time. So if they become sick, that it was absolutely within the time that they were subject to the call of the vessel. And that's intended to protect those who are sailing, you know, outside of US waters and would really need the help. These laws go back to before there were cell phones and before anyone had the ability to call someone back in the States really easily and get flown back. So that would change the analysis.
turning our attention to many organizations utilize Merchant Marine Academy students who are seeking a summer co-op or work experience. Are they, if it is part of their academic program, therefore, while they may be getting paid, they're still a student, has there been any case law that has sort of given guidance on whether or not maintenance and cure is applicable in that situation?
That's a great question. I haven't seen any cases with that exact fact pattern. I think the first question I would ask is whether or not it was a sailing school vessel. If it's not a sailing school vessel and it's a T vessel or some other type of vessel, then it doesn't matter that the person is a student during the year. If they're there performing, the duties of a crew member, then they're a mariner. The exclusion would only apply to sailing school vessels that does have that student exclusion. And I think what would be relevant is whether that person, that injured seafarer, was a student on board the sailing school vessel. So is that person a participant in the program being offered by that vessel? Or is that person actually signed on as a crew member, deckhand, or a crew member, third mate, or that sort of thing? That, I think, is the intention of where that distinction lies in the 1982 legislation.
Two sort of semi-related questions. What's the protocol regarding pre-existing conditions, or how is that addressed within maintenance and cure? And likewise, what about a mariner that refuses medical care or refuses to go get evaluated or seek care, despite the fact that it's apparent that there's illness or injury present?
So those are fantastic questions. First, with regard to pre-existing conditions, with my clients, and they're generally not tall ships. There are a couple that I advise, but for the most part, they're merchant vessels that are moving cargo or goods. I say that every single employee has to have a pre-employment physical. It has to be detailed, and they have to be asked questions that elicit a response to whether or not they have pre-existing conditions. So, do you have drug and alcohol problems? Do you have back problems? Do you have knee problems? All these questions that the employee then answers. And the reason to have this pre-employment physical or pre-employment health questionnaire signed by the seafarer is that there is case law. There's something called the McCorpin defense. It comes out of the Fifth Circuit, which is New Orleans and that area of the United States, that says that if a seafarer lies to his employer or her employer before signing on the vessel and says that they're fit for duty and conceals a pre-existing injury, then when that pre-existing injury or condition rears up, the employer is not obligated to provide maintenance and cure for that condition. So if an employer doesn't ask questions, then the employer or prospective employee can't lie because they haven't been answered a question, they haven't been asked a question, and then you're not entitled to that McCorpin defense. But if you ask a potential employee, do you have back problems, do you have knee problems, and go down the list, and do it in paper, certainly, so it's documented. And if they say no, and then they come in and say, my knee's really bothering me, I think, I need to go off duty for a bit and be sent to the doctor, and it turns out they've had, 3 ACL surgeries, then you're gonna be like, you know what? We wouldn't have hired you if you knew that you had 3 ACL surgeries, and you lied to us when we were hiring you about the condition of your knee. And so under the McCorpin defense, you actually aren't obligated. So that was the first aspect about pre-existing conditions. If they're not asked about and therefore not lied about, then you are obligated to provide coverage for them. The other part of the question I forget now. What was the other part?
Individual that refuses to seek medical care at an apparent injury or illness.
Yeah, so there are defenses to maintenance and cure even when they would otherwise be due. So if you have a seafarer injured while subject to the call of the duty, who would be entitled to maintenance and cure, their willful misconduct, which is the phrase that's used by the courts, which can be non-compliance with medical orders, will break the obligation to provide maintenance and cure. So if, for example, the seafarer refuses to comply with the restrictions imposed by the physician or refuses to go see the physician, then there's only so much you can do. And so then the obligation to provide those benefits will be terminated.
And
but again, before terminating them, make sure they've really, really, done the wrong thing, so you're not exposing yourself to punitive damages.
And I would guess document some more, that they're refusing. It's kind of like AMA, yes, or refusing medical care, etc.
Yes.
Lots of great questions coming in. Folks, just a reminder, if you do have questions, please do it in the Q&A. It's easier than having to switch back and forth and read sort of parallel text in the chat group as well. There are a couple questions about the relationship between health insurance, either individuals that have health insurance, the ability to use that to meet a Jones Act obligation, company provided health insurance to meet Jones Act obligations, and then sort of I'm going to throw in the one about utilizing workers' comp insurance to meet Jones Act obligations.
Yeah, so there are different kinds of health insurance plans. Some vessel owners and operators buy the super expensive, this health insurance will cover you even if you have an industrial injury insurance. And that means that even if your employee is injured on the job, so it's an industrial injury, that health insurance will cover the treatment for that injury. And it is well settled that that kind of insurance is great. It reduces the cost for the employer. It reduces the cost for everyone. You run through that insurance first, and then the copay or any amount over and above is the employer's obligation to pay. Many insurance policies do not cover industrial injuries, and so then it falls upon the employer to pay directly. And you're not supposed to run an industrial injury through a health insurance policy that says we don't cover industrial injuries. I've seen employers do it. They're not supposed to. It's not ethical. The insurance company, if they get wind of it, is going to come back and demand you as the employer reinstate those amounts because it shouldn't have been covered by the insurance policy. But that's sort of, it's one of those messy situations. In terms of meeting the obligation, though, that health insurance has to be provided by the employer in order to be an adequate means of providing this coverage. So if you tell your employee, sorry, we don't provide benefits, you have to get your own health insurance, and then the employee gets health insurance from their spouse or goes on the open market and buys health insurance, the employer can't be like, well, just run that for your health insurance and then we'll pay the co-pays. If the employer is not paying for the health insurance, they can't rely upon it as a collateral source of paying the cure. With regard to workers' comp, so at least in California, and that's the scheme I am familiar with, in California, you are not supposed to file for California workers' compensation if you are a mariner protected by another scheme. So it is, in essence, a defrauding of the California workers' compensation program to try to withdraw workers' compensation benefits. Certainly doesn't mean I haven't seen clients do it. I have seen a lot of clients say, why don't you just go file for unemployment because then the money comes elsewhere. But it is certainly not what you're supposed to do. I would say it is ill-advised, and it rarely ends up being the right approach.
With relation to health insurance, it would seem like maybe if a crew member is employed year-round aboard a vessel, it's not worth them getting their own health insurance. But the maintenance and cure is really about when they're on the ship in service to the ship, right? And it's not designed to cover when they're on an extended leave or something similar, correct?
Right. So if you think about someone who maybe signs on for the season and then signs off for a few months and goes home and spends holidays with her family or that sort of thing, to not have insurance when you are not on the vessel means that if you get in a car accident or, God forbid, develop cancer or something like that, then you have no insurance. So certainly would not recommend that anyone not get insurance and then rely upon maintenance and cure, because I don't know of anyone who is 100% subject to the call of the vessel. Everyone has to take some time off or be a commuter seaman who has weekends off or something along those lines. And so during those time periods when you're not subject to the call of the vessel, if there was a catastrophic injury, being uninsured would certainly be ill-advised.
Has there been any case law that deals with this issue? Let's say that crew members are living ashore in a crew house that's paid for by the company, and an injury happens not on the ship, but ashore at the house or in transit to the house or similar. Sort of pseudo-commuter, but you're commuting to a place that's also provided by the company.
Yeah, so that's where things get really hairy and lawyers get really excited because you just get to argue and argue and argue. if you're supposed to be there and if it's provided by the employer, then it is much more likely to be found that you're still, subject to the call of duty, and therefore covered. There has been, there was actually a case that my firm handled. I didn't handle it, but one of my partners did, where an employee got, Lyme disease. So got one of those diseases that was transmitted by an insect or a bug while the person was in the yard area. So, the vessel's tied up at the dock and they were on shore dealing with something that was unrelated, but I think they had set up a tent and were living there because of who knows why. And it just becomes a huge mess. So, if it's employer provided, then you're probably going to be on the hook, and courts are going to find in favor of giving benefits to the seaman or seafarer. But then again, really in reality, you have to trace where the illness or injury comes from, and the first reaction should always be to provide maintenance and cure, because you can always then dial back and stop, but you don't want to not provide them when they are due.
We've just come to the official 1 hour mark. So do you have a few minutes to stick around and answer a few more questions, or I don't know what your time commitments are? Two, for those that do have to leave for other commitments, are there any sort of recommendations you could make for a good place to start doing some more research about maintenance and cure and all of these issues, and maybe some of the case law for the layperson, in addition to certainly an organization reaching out to legal counsel or whomever they sort of keep close by?
Yeah, that's a great question. There's a practice guide, but it's not inexpensive, so that's probably not going to be a good place to start. But as much as I hate to say it, if you do a Google search on these things, you'll generally be brought to a number of plaintiffs' attorneys' websites, and the plaintiffs' attorneys' websites generally do a decent, albeit litigation-leaning side of explaining what the laws are and what the rights are. Of course, plaintiffs' lawyers want you to sue, because then when you get a big pile of money, they take 40% of it. But there is some good explanation and citation to the applicable rules that can be found online. I think that those who are on the operations side should have a friendly maritime lawyer that they can talk to. I know that in my case, I have talked to a lot of tall ship owners and operators and answered questions off the cuff really happily, without charging them for that, just because I respect the industry, and I know there are a lot of former mariner lawyers out there now. So for basic questions, but it's a really important area of the law, and it is really important for operators and owners to understand the risks involved. So it's something to make sure you understand in terms of the obligations.
Great. I'm going to say an official thank you very much to Juliet McCullough for her willingness to participate in this session. I know a lot of people found it remarkably useful, as has been commented upon. She's been kind enough to say she could stick around for a few minutes. I'll keep firing away the questions, but for those of you that do have other commitments, thank you for joining us, and we look forward to hosting another webinar regarding risk management and the case for reopening. So once again, Juliet, thank you so much, and we'll keep the questions coming here in just a second. One that seems to come up from several people is dental care, and whether or not dental care is covered in the Jones Act.
That's a great question. So that's one of those questions I put in my pre-existing for employers before they take someone on is, when's the last time you went to the dentist, and how was your dental checkup? If a seafarer is on board a vessel and all of a sudden needs to go have emergency dental procedures, that's something that manifests while subject to the call of the vessel, so that is going to be covered under maintenance and cure. The good thing about dental issues is that they're generally pretty short-lived, and you can get back to work more quickly than a lot of other issues, but they are covered just like if someone, there is case law, and sad as it may be, about mariners who develop cancer while on board, and stunningly enough, it becomes the obligation of the employer to pay for the cancer treatments because it manifests while the seafarer is on board the vessel. So there's really no discrimination as to what type of injury or illness manifests in terms of giving rise to the obligation to provide maintenance and cure.
Great. You had mentioned earlier that the maintenance and cure obligations and those other sort of access to punitive damages, this is all regarding U.S. flag vessels, which are subject to U.S. law. You mentioned that foreign flag vessels are not subject to those laws and regulations, but are subject to laws of their respective flag states. Any guidance or suggestions for U.S. mariners that are looking at positions foreign flag, be it, look out for certain flag states or be aware of certain sort of international regulations under ILO or that come out of the IMO?
I wouldn't say that there are any flag states that I would necessarily be wary of, because I like to think that most employers will do a good job of taking care of their injured employees, even if it's not providing these really extensive benefits. But I also am not a specialist in other countries' laws. And so you will get stronger protections as a U.S. seafarer sailing on a U.S. flagship, certainly. There aren't any other countries that compare in terms of our protections. I have a lot of clients in Europe and London, and they say the absolute worst place that a seafarer can get injured is California. So yeah, that's a little bit of a bummer for all of our California vessels. But the U.S. is more litigious than the rest of the world. We really, really like to sue people, and so in other countries, it's really more of a workers' compensation scheme, like the shore-based workers' compensation scheme. I know I handled a matter for a bulk carrier, and it was a Chinese national who was very severely injured and had to be in the ICU for a long time after being life flighted, and he's going to get some very small fixed amount of money. That's what's designated by the law in China for an industrial injury, as opposed to if that had been an American who was sailing for an American company with his injuries, would be looking at millions of dollars. So the protections are better here, but don't shy away from sailing on Blue Nose or some other vessel that is not U.S. flagged. If it's something you really want to do, just stay safe while you're out there. Do your best to stay safe.
Great, thanks. Just a couple points of information that have been shared in the chats and the Q&A. There was a comment made by Tall Ships America Chairman Mike Raworth that organizations should have coverage under their hull and P&I insurance and other protections that are sort of part of their normal coverage. Chris Richmond chimed back that newer policies are being written with COVID-19 exclusions. So that's something you definitely want to clarify with your carriers so that you're not exposing yourself to a liability, especially in these tumultuous times.
If I can just jump in, one of my partners was asked by an underwriter to provide opinions on whether or not, as a matter of public policy or maritime law, it would be okay to have these COVID-19 exclusions. And I didn't do that legal research. I didn't dive into it. That's something that he was doing for his client, the underwriter. But basically all the rest of my partners and I chimed in and said, I would never, ever, ever, if asked my opinion from a client, say, yes, go ahead and buy a policy that has a COVID exclusion. That seems like a huge risk exposure that can't possibly be worth the savings and premium. So exclusions to coverage are generally not what you want, because it only takes one really bad case to bankrupt a company.
There are some comments and questions about for organizations looking for guidance on handling COVID-19 aboard their vessels. And I would direct everybody, and I'll type it into the chat bar in a second. If you look at the U.S. Coast Guard marine vessel inspection circulars or the marine safety information bulletins, there are several documents that give guidance in terms of what an obligation is for a vessel operator that range from contacting the captain of the port if there's a case of COVID-19 on board. And likewise, there's tremendous guidance from the CDC. Historically, it's just sort of anecdotally interesting that the origins of the CDC and the Public Health Service really stem from the ability to care for merchant mariners that came down with illness and injuries aboard U.S. flag vessels sort of from the inception of our country. So when you have a free moment while you're staying at home, it's worth a little bit of a dive on the Public Health Service website. They have a great history that sort of covers seafarers hospitals, just anecdotal information there. There were some more questions just pertaining to the potential for recurrent injuries, or somebody that has, a back injury that, went away, but the potential for re-injury, and sort of how that plays into maintenance and cure vulnerability.
Yeah, so that's a really interesting question, because there's case law that says that if you had a back injury and then you leave the employer where that injury happened, you get declared fit for duty by a physician, honestly. You're honestly better, you're honestly at maximum cure, and the physician honestly believes that you can return to duty. You disclose it during your pre-employment period, so whether that's by filling out a health assessment or going to a physician, but you don't hide it, you're not dishonest about it. And then it flares up again. The seafarer actually can choose to try to collect maintenance and cure either from his original employer or her original employer or the current employer. And the case law says that you can have serial suits for maintenance and cure. So if you have a condition like, a back injury that will flare up, you can reach maximum cure. The doctor says there's nothing else we can do medically to make you better at this point. So you're at max cure, terminates the benefits, and then a year goes by and it flares up again. You can go back and ask that employer to reinstate the maintenance and cure. If you're working for a different employer at that time, then of course now you have a condition that has manifested while subject to the call of that vessel. So you can seek it from one employer or the prior employer. Often what happens is that whichever employer the seafarer seeks the benefits from, that employer will end up suing the other employer and getting them in the mix and saying, we have to share this obligation. But there is an entitlement to bring serial suits. So if, for example, someone didn't go back to sea and instead, started working in some shore-based capacity, they can go back to the employer who they had at the time of the original injury if their condition flares up, or case law says if medicine advances such that there's a new procedure that could cure them. So if they have this really disabling back injury, but the physician says there's nothing else we can do for you right now, we can't make you better, I'm sorry, you're gonna live with pain for the rest of your life. And then medicine comes up with a new, fusing procedure that would help this person gets to go back and say, hey, I was at max cure, there was nothing else that could be done to improve me, but now medicine has advanced and there is something that can be done to improve me, you gotta pay for the surgery. Then the employer is supposed to reinstate maintenance and cure.
So there's no statute of limitations in terms of when a former employee can go back and say, I was injured here and it manifested itself now, et cetera?
So there's a statute of limitations, which is different from the ability to bring serial suits. So the statute of limitations for a claim for unseaworthiness, negligence, or maintenance and cure is 3 years. And that's 3 years from the date that you realize you have a claim. So when you're injured, you should realize that you have a claim when you feel that you are injured. But if that's resolved and you go about your business and then 5 years later it flares up, then the 3 years begins from the day the injury flares up again. And so it's a really challenging part of being a marine operator, the fact that these serial suits can be brought. Of course, generally in the merchant side, there's some sort of settlement that is reached between employer and employee that says, this is a full and final settlement, regardless of whether my injury flares up again, regardless of what may happen in the future, regardless of anything else, like we are done and wiping the slate clean. And that release would terminate the right to bring serial suits for maintenance and cure.
And just to reiterate, I think we covered it earlier, but foreign flag vessels, even if they are operating to the U.S. or calling into the U.S., are not subject to Jones Act or to maintenance and cure?
If you can establish personal jurisdiction over them, then they are. So if there is an employee who is injured and injured within U.S. waters, and they want to sue in the U.S. courts, the U.S. court will not say, I'm not adjudicating this because the defendant is not American or the plaintiff is not American, as long as there is personal jurisdiction, which means that the court can enforce a judgment. So if the foreign company does enough business in the U.S. that there would be a means of enforcement of a judgment, then there's going to be personal jurisdiction over the defendant. But there also is supposed to be something called venue, which means that the court has an interest in the litigation. So if you have a foreign defendant operator, a foreign plaintiff injured seafarer, and the injury occurred outside of US waters, the court's gonna be like, what? I have a very busy docket. We're totally overloaded. Why is this in front of me right now? There's no connection to this district or this courthouse that this should be in front of me. And so then you would most likely find the defendant filing a motion to dismiss and saying, there's no reason for this case to be happening here. And then it would likely be dismissed.
So it sounds like if you operate a foreign flag vessel calling into the U.S., seek some legal counsel regarding your exposure to maintenance and cure liability pertaining to a U.S. mariner, certainly.
Yeah, and so most of the, you know, the big merchant ships are members of something called a Protection and Indemnity Club, which is based in London or in Europe. Most of the clubs are in Europe, some are in Asia. And one of the benefits of those clubs is that they have listed correspondents in every port. So when I do work, for example, for a foreign flag vessel, it's because I'm a listed correspondent for a Protection and Indemnity Club based in London. And so we get a vessel that comes into the San Francisco Bay and has this urgent need, and they open up their book and they look for who the correspondent is in San Francisco Bay. And then their trusty maritime lawyer, Juliet McCullough, picks up the phone at 2 in the morning and answers their question for them. It would be harder for a tall ship that may not have the benefit of being a member in a Protection and Indemnity Club. But certainly having some connection to a maritime lawyer would be helpful. Of course, the most helpful thing would be to avoid injuries.
And then are you up for one non-maintenance and cure cabotage law question regarding the Jones Act?
Yes.
Can a foreign flag sail training vessel embark and disembark students coastwise in the United States?
So I don't know of an exclusion for a sail training vessel. There may be one, but generally speaking, a foreign flag vessel can't go between 2 US ports and carry either cargo or people for pay. Now, if it's a sail training vessel and it's not for pay, that might be an exemption, but I'd want to dig into the law before I answer that.
And I think just having seen this question come across my email recently, the answer is yeah. This wasn't a quiz, but I think yes. The person that's asking this, if you want to email Chris with a K at Tall Ships America, she can forward it on to Mike Raworth, who I think was the person that commented on this and said that there was some exclusion because sail training. There's a specific CBP ruling that says yes. Mike Raworth chiming in. So yes, it's okay. So there we go. Thank you very much, Mike. And I think we've now covered all the questions in the queue. We'll give everybody one last chance to chime in if there are any other questions. Otherwise, Juliet, I will say thank you very much once again. This was really informative for folks, myself included. And it's great that you were so willing to give of your time and knowledge to share this information with us. So thank you once again. I see Chris, our fearless executive director, coming back to us.
I just want to say thank you, Juliet. This was really good, and the engagement was fantastic with everyone. We will have the questions and the recording on the website and sent out to all the attendees. So thank you very much. Again, there will be a survey, so please respond to the survey and let us know what you'd like for us to cover.
There was one final question, which was about marine techs, non-ship engineers, other people doing business aboard ship like a research vessel. And offhand, if you knew if they were covered for maintenance and cure, or is it case specific?
Are they on there like resolving a particular issue? They've been brought aboard to? No,
they're conducting the affairs. Let's say they're, you know, the marine techs on a research vessel that run the ribs and do science, but with boats and boaty things, as opposed to being directly in service of the main research vessel.
Yeah, you know, I don't know of the exclusion for research vessels well enough to answer that offhand. I'd want to take a quick look and see if there is an exclusion there. Generally speaking, anyone who's working on the vessel more than 30% of the time is considered a seafarer. So if you meet that element, you know, keeping the vessel moving, so doing some sort of tech or would be considered aiding in the mission of the vessel, unless there was an exclusion. So basically the answer is yes, unless there's a statutory exclusion that has been.
If I recall, I think UNOLS has certainly published a lot of guidance documentation on that, and it's easily Googleable. So I would take a look there and you should be able to find the answers to those questions specific to scientific personnel aboard research vessels. There we go. So thank you once again, Juliet, for joining us today, and we look forward to seeing you all again sometime soon.
You are very welcome.
Thank you.
Thank you, everyone.
Thank you.